In the very first lecture, I said that the law is the rules to the game. The law explains how players are going to play the game. And one of the things that the law does is to provide a framework that permits the resolution of employment disputes. And so there are two ways of resolving employment disputes. It may be through public methods or private methods. We know that disputes often arise between an employer and its employees. That this is a thing that happens. I didn't get paid enough. I got discriminated against. I didn't get my overtime. Disputes will often happen between an employer and its employees. And we know that these disputes oftentimes are resolved in a court, in the court system. And resolving disputes in the court system is a process called litigation. And so when I talk about litigation, I'm essentially talking about the public resolution of employment disputes. It's important to understand the court system for you to manage employees, because you have to understand that sometimes how we resolve a dispute is just as important as the merits of the dispute, meaning procedure can be as important as substance. So in this lecture, we're going to look at the forms of dispute resolution, specifically public dispute resolution, used in employment law. First of all, employment disputes may be resolved in state or federal court. The United States has a very convoluted court system. In fact, we don't have one court system. We have 51 different court systems because every state has its own court system and the federal government has its own court system as well. Now, fortunately for our purposes, the court systems are going to be organized in much the same manner. There are differences, and we'll talk about some of those, but in essence, when I talk about the court system, it applies to both the federal court system and the state court system. Both systems include multiple levels of courts, meaning there are lower courts, there are higher courts, and then there's a highest court, a Supreme Court perhaps. In this system, the lowest court is called the trial court. And the trial court are the ones that you see on TV, in which there's a trial being held, and there's a plaintiff and a defendant, and oftentimes a jury sitting there. And those courts, they are the lowest level of the court system, but they have really one of the most important roles, which is to decide the facts of each case. That's the job of the trial court, is to make a determination of the facts of the case, that what happened. You know, in a car wreck case, when you're crossing the road and someone runs a red light and you say, I had the green walking man, and they said, no, I had a green light. Well, that question of did they have the green light or not, that's going to be decided at the trial court level, usually by the jury. Appeals courts, however, will focus on questions of law and not on questions of fact. When I talk about questions of law, what we're really talking about is, did the lower court, did the trial court apply the law correctly? This often comes up, again, from TV. You've seen people objection, and either sustained or overruled. Well, when a judge at the trial court level sustains or overrules an objection, that is a decision of law. And so when I file an appeal, if I file an appeal, I can only appeal those questions of law. It could be admitting evidence that should not have been admitted, or refusing to admit evidence that should have been admitted. Those are the kinds of questions that the appeals court will focus on. And finally, it goes to the highest court, the Supreme Court, And the fact is, in our system, the decision of a state Supreme Court as to state law is the final decision. The Supreme Court in both the state and federal systems, again, can only decide questions of law, and if the question of law is based solely on that state, then the decision of that court is final as to the proper interpretation of that law. Now, the federal court system has 3 levels as well. Every state has at least one U.S. district court, meaning the trial court of the federal court system is called a district court. Every state has at least one of those. And U.S. courts of appeal hear appeals from trial courts within their district. There are 13 different courts of appeal that are based on geography, and they hear appeals from all the district courts within their particular region. The United States Supreme Court, of course, is the highest federal court. The United States Supreme Court does not have to hear every appeal. The ability to appeal to the Supreme Court is discretionary, and in fact, the Supreme Court only hears about 2% of the cases that are appealed to the Supreme Court. The rest of those cases are determined by the appellate court's rule. Now, again, fortunately, similar procedural rules, meaning how do we resolve the dispute, apply in both state and federal court. Every new lawsuit goes through certain stages, beginning with what we call the pleading stage. And pleadings are those documents that set out each party's claims and defenses. In the pleading stage, the plaintiff will file an initial pleading to start the lawsuit. And in federal court, we call that a complaint. The plaintiff is the party seeking relief against the defendant. So the plaintiff files what's called a complaint. And the complaint is meant to be simply concise, factual allegations of what happened, which is to say, Jane Doe was an employee of XYZ company. Jane Doe was hired on October the 1st. On October the 5th, Jane Doe was terminated, and then Jane Doe was terminated because of discriminatory practices. So it's just a recitation of the facts of the case, which is designed to put the defendant on notice of what it is being charged with. The defendant employer will respond to the complaint with a document called the answer. And these are the first 2 documents that are going to be filed, the complaint and the answer. And the answer is meant to address the issues found in the complaint. And in the federal court system, the defendant has to reply to each and every allegation made by the plaintiff. If the plaintiff says it was hired on October 1st, the defendant must acknowledge, yes, that's true, or say, no, the defendant was actually hired on October 2nd. The defendant has to respond to each allegation found in the complaint in the federal court system. The defendant will admit or deny each of the allegations made by the plaintiff. And then at trial, the jury is going to serve as what we call the finder of fact. And the jury will decide what are the actual facts of the case. We're going to leave that up to this third party, the jury, to decide the facts of the case.